So today we're finishing up the NVAR sales contract. Last week we did paragraphs 1 through 12. Today we're going to start on paragraph 13. So hopefully you brought your paper with you from last week. If not, I made a couple extras, but they look like they're all gone. So share with your neighbor. All right, paragraph 13 is the IRS FERPTA paragraph. This is the withholding taxes for foreign person. And here you have to check whether or not the seller is or is not a foreign person, as defined by the Foreign Investment in Real Estate Act. If seller is a foreign person, buyer may be required to withhold and pay to the Internal Revenue Service up to 15% of the sale price on behalf of the seller and file an IRS form which includes both seller and buyer's tax ID numbers. The parties agree to cooperate with each other and settlement agent to effectuate the legal requirements. So if you're the buyer agent, right, you're filling this out, you don't know whether or not the seller is a foreign person or not, as defined by FERPTA. So the best way to find that information out is to call the listing agent, or hopefully the listing agent has in the documents section the how to make an offer sheet, which in there, one of those things is whether or not the seller is FERPTA. If you don't know whether the seller is a FERPTA required person, then don't fill it in. Don't check the box for the seller. Make them take care of it. Sometimes I'll highlight it. If I don't know, and the buyer and the listing agent never contacted me back, I will highlight the paragraph so that they realize that they have to there's a check mark there for them to fill in. So I may have to initial that with my buyer when it comes back, but don't fill it in for the seller, just because if you check that they are, and they are not, or they are not, or they is not a foreign person and they are, you could mess up, put your buyer at harm's way as well for being tax liable for revenue that seller may have made on the property. So make sure that you don't check that box, okay, as a buyer agent. If you have any questions regarding FERPTA, I pulled it up. It's easy to find information on FERPTA. The IRS website has lots of information regarding requirements. Also, just because they may or may not be a green card holder, or they may not be a green card holder or a U.S. citizen, there are other ways that they may or may not have to pay taxes on at that particular time for that property. So you can always look on the IRS website. All you got to do is Google FERPTA. All kinds of wonderful information you can find out. Make sure you go into reliable sources, though. When you're on the internet, don't try and get your information from a reliable source, because there is a lot of stuff on the internet that may not be totally 100% factual. So try and use reliable sources. This one right here is the IRS website. So you can search this website, do whatever you need. But like I said, all I did was Google FERPTA, and this came up. Questions on FERPTA?
The title company will be the responsible to hold for the FERPA?
Yes, the title company will be the ones that will follow the regulations in regards to any FERPTA withholdings. If for some reason you feel that your client, the seller, may not be required to withhold the whole 15%, you could do the research and provide that to the title company, and they'll either adjust it as needed, or they'll tell you why that doesn't hold true for your particular seller. One thing too to remember is if you have say joint ownership in a property and one person is FERPTA and the other one is a U.S. citizen, guess what? They still have to hold back a certain percentage of those proceeds due to the fact that there's one owner that is not a green card or U.S. citizen. So be cognizant of that fact. If you're working with multiple owners on a property, if one is a U.S. citizen, that does not automatically mean that the other recipients of the proceeds are not FERPTA may not have that FERPTA withholding against them. Paragraph 14 is smoke detectors. This is just making sure that everybody understands that the property will be delivered with working, functional smoke detectors, which are required by Virginia law. Pretty easy statement, right? So if you didn't even do a home inspection, you did no home inspection, you went and did your walkthrough and the smoke detectors weren't working, the seller is still obligated to have those smoke detectors in working order. So no ands, if, or buts about that one.
How many smoke detector is required?
And that varies by when the property was built. So building code would regulate how many smoke detectors and where they're located. Like homes that were built, say, prior to 1950 may only have one smoke detector per floor. Homes that were built later on may have one in every bedroom, one in every hallway, and they're all wired in together. So if one goes off, they all go off. So it's going to vary. I couldn't tell you which one falls under which, but whenever that home was built, they built that home under the requirements for smoke detectors at that time. The house I grew up had no smoke detectors, right? We were all dead, right? But we're here today. We made it. We made it. It's amazing. Paragraph 15 is lead-based paint. This is the paragraph that's just denoting whether or not the property was subjected to or built before 1978 and whether or not you're waiving any lead-based paint assessment. So if the property was built, there's normally a disclosure for that. That should be a part of your package. Once again, as the buyer side, don't fill out that disclosure for the seller. It's the seller's obligation to disclose to the buyer whether or not they have any evidence of lead-based paint or whether they have any documents pertaining to lead-based paint for the property. Don't fill out that form. I know we want to make it easy for the selling agent or the listing agent to ratify our contract, but don't fill out the forms, I mean, for your client because you're giving away potential contingencies in your contract by filling this stuff out for the other side. So just if you don't know the answer, if you know it's built prior to 1978, that's easy enough, right? But don't fill out the lead-based paint disclosure for them. So you can check the appropriate boxes in here. I would check the box, or I would check the box on the additional forms, and then off to the right say not provided, right? Because at the time of your contract, it wasn't provided, right? So, and then if you're going to do lead-based paint an assessment, there's a separate addendum for that. Now, lead-based paint assessment is where they go in and they pluck off pieces of paint from the property in different areas, and then they assess it for the content of lead. Now, if you are working with a buyer and they're majorly concerned about lead in a property, don't show them properties built prior to 1978, right? Stick with properties that are newer, because trying to get a contingency through with lead-based paint assessment is very difficult. Why? Because if they do go in, and most properties may have the presence of lead-based paint that were built prior to 1978, if you do now have a report that says that this property has lead in it, now that seller has to disclose to every potential buyer that there's lead in the house. We all knew there was lead there anyways, but now all of a sudden there's a little stigmata on the house because they actually have a report now that says that they have lead in the property. Do you know how expensive it is to remove lead from a property? Very expensive. So a seller and a listing agent, a savvy listing agent, are probably not going to be overly excited about granting you a contingency to do lead-based paint assessment in their property. And as a buyer, if I have clients that are overly excited about lead in a property because they got small kids and their kids like to suck on the windowsills for whatever reason, right? If they have little kids who like to do that and they're worried about lead, show them properties that were built 1978 or newer, right? So just my advice, my humble advice, but you know. Any questions on lead-based paint? Excellent. I'm an unbelievable educator. Wood destroying insects. So this paragraph is whether or not your client is going to perform wood-destroying insect inspections. So whether or not they're going to do it, whether or not the buyer is going to pay for that, or whether or not the seller is going to pay for that. You're going to check the appropriate box on here, and then it has to be done 90 days prior to settlement. So if you have a long, dragged-out settlement, you probably want to wait till inside that 90 days. Now, not all loans require a wood-destroying insect inspection. So if you're competing and you're trying to remove things from your contract and all that kind of stuff, if you're conventional financing or cash buyer, you don't have to necessarily do these type of things. But if you do, make sure you check the appropriate box. Just as an agent, be cognizant of the fact that this paragraph says that they're going to do the WDI, they're going to provide a report, and they're going to determine whether or not it is free of visible evidence of live wood-destroying insects and free from visible damage. So you get your report, and that report says evidence of dead insects. Does your seller have to pay for treatment? No, right? They don't. Now, if they find structural damage or that kind of damage, but evidence of dead termites, or the big one around here too is carpenter bees. Lots of carpenter bees, right? If there's a wood deck attached to the property or something of that nature, you might find carpenter bee holes, all that kind of stuff. So those carpenter bees, they're part of a wood-destroying insect. It's not just termites, right? So anything that's going to bore into the wood, destroy the wood, the seller could potentially end up paying for treatment for that. And so here it does say the seller will provide the buyer and the buyer broker representative licensed pest firm selected by the appropriate party. So if the buyer is doing it, and then they have to provide their report. And then the seller, at the seller's expense, will provide written evidence of treatment or repairs prior to the date of settlement. So if you're the buyer representative, don't wait till the last. I know we all want to wait till we get through the home inspection before we start spending our clients' money, but don't wait too long, because the closer we get to settlement, the harder it is for the seller to make repairs. So try and get these things done as quickly as possible, so that if you do need any type of repair or treatment, it can get done prior to settlement. Questions on WDI, wood destroying insects? Excelente. Paragraph 17, home warranty. This paragraph has a lot of concern and a lot of problems with it. No, just kidding, just making sure you're awake. Home warranty, this is just where you're asking the buyer, the buyer is asking whether or not the seller will pay for a home warranty, or whether they want a home warranty and they're going to pay for it themselves. So at Sampson, right, when you put your listing in into SkySlope, it will automatically generate a seller's home warranty coverage during the listing period. You can convey that coverage onto the buyer if you choose to do so, if that's part of the contract, or you can let it expire at the time of settlement. But here, as your buyer, you could ask the listing agent whether or not they have a home warranty on the property and whether it's going to convey. A lot of times they'll advertise it. If not, it could be part of your package. As you awesome real estate agents are, you could offer a home warranty to your buyer client and pay for that at settlement for them as well. That's home warranty. Paragraph 18 is damage or loss. So this is just a caveat that says the risk of damage or loss to the property by fire, acts of God, or other casualty remains with the seller until settlement. So things happen to properties. There's storms, especially if you live in Florida or North Carolina or Tennessee. But you can have storms, right? And things can affect the property when it's under contract. It's just because it's under contract, the property hasn't conveyed to the buyer, so it's still the seller's responsibility, right? So if something happens to a property during the time of contract, and they have let's just say a hurricane that, maybe they get some damage to the exterior of the property, well, they may not be able to have that repaired prior to settlement. So there's nothing that says that the buyer and the seller can't negotiate an extension until all that stuff gets repaired, and then they can do their walkthrough and everything is good to go, right? It doesn't necessarily mean that your buyer has to walk away from the property just because there was some damage. Paragraph 19 is title. Now this paragraph goes into how the buyer and the seller are going to agree to convey title, all that kind of stuff. But I've noticed some things in here that sometimes seem to get missed, right? So a lot of times, right, people will call and they'll say, hey, Steve, my client, the buyers, we presented the homeowners association documents to the buyers. The 3 days expired and there was some repairs noted in there. The seller doesn't have to do anything with that, right? Well, just because the buyer reviewed the HOA docs and decided that there's nothing in there that they are not okay with in regards to the documents themselves, does not relieve the seller of making any repairs or whatever the HOA or condo association had denoted as deficiencies for that particular property or unit. And I'm going to highlight this one paragraph in here that says the seller will pay any special assessments and will comply with all orders or notices of violations of any county or local authority, condominium unit owners association, homeowners or property owners association, or actions in any court or account thereof against or affecting the property at settlement. So this is telling you that the seller has to convey that property with those violations removed. Now that doesn't mean as the buyer's side, if the seller can't do it for whatever reason, we can't negotiate mutually acceptable terms in order for your buyer to accept those violations. Now say there's a fence that was put up around the property in the rear part of the property that wasn't approved. So now you have, and the seller's like, I'm not going to do anything with that fence. That fence been up for years. I'm not doing anything with it. Well, you have to make a decision now with your buyer on whether or not you're going to proceed or not proceed. Because once your buyer signs on the dotted line at settlement, those are now with the property. So whatever violations or non-approved alterations to the property were done by the previous owner are now your responsibility as your buyer, right? So make sure that you, I always review the HOA or condo docs for those particular things or anything that my buyer may have said to me that could be a potential restriction to the property usage, right? So I might have a client who is a contractor and he has a work truck. And some communities don't allow contractor trucks parked in, they have to be inside the garage. They can't be parked on the driveway over the weekend or at off hours. So that could be a restriction for my particular buyer. So I want to make sure I'm not putting a potential buyer and a referral source for many, many years to come in a situation where they just bought a house that they can't put their truck in, whatever, in their driveway. So make sure that you keep a note of those type of things when you're working with a particular client so that when your client reviews those HOA or condo docs, they can use the property for what they want. And I'm also looking for any alterations or violations so that I can send a courtesy notice over to the listing agent that says, hey, we've reviewed the HOA docs and the following deficiencies were noted, and I put them down on there. The buyer is expecting the seller to have these issues rectified prior to settlement. And then it's a notice. You don't have to send it as an addendum. It doesn't require the seller to sign it. It's just your client, the buyer, giving a nice courtesy notice to the seller that says, hey, we saw these issues. We just want to make sure they brought to your attention. We expect them to be repaired prior to settlement. Please do so. Thank you very much. And there was a question?
Steve, on this particular sentence, have you seen any case law or any situations in the company whereby the seller refuses to make the repairs and or asks for such a delay that the purchaser denies that and then asks to be released from the contract?
I mean, I've never heard or seen of any of these go to legal here at Sampson since I'm aware of. I have seen disputes regarding the issues, and in most of the cases, the buyers will accept the property with whatever those violations are, because normally, in most cases that I've heard, we're talking normally violations to rectify that are normally less than, say, $1,000. So the question is, at the end, the buyer can take possession and then go back, and you could, as a buyer agent, you could send some sort of official notice over that says that the buyer is accepting the property with the current violations, however, reserves the right to seek legal opinion. Then after they settle on the property, if they want to take the seller to smallest claim court, they could for whatever they had to repair. So, but I haven't seen any that have ever gone far. I mean, I probably would. I've seen ones that have gone to a point where they have voided the contract. We had one years ago where someone had put a front porch on the property, which had caused some sort of a setback there was some sort of I don't know if they didn't do permits or whatever the issue was, but the porch was encroaching on either an easement or a setback issue, and in order to fix it, they were going to have to lop off half of the porch, and it was going to have to be a strange design so that it didn't impede this easement or right of way or whatever setback. And the buyers decided they wanted to void the contract, because once they made these alterations, the property would not convey in substantially the same condition as of the contract date. So they all agreed to mutually void the contract and walk away. So, thank you, ma'am.
Title insurance is usually very expensive on the settlement. My experience, lots of buyers don't want to pay the title insurance at settlements. Can you talk about that a little bit? And can you tell me?
The buyers don't want to pay the title insurance at settlement. I am a huge advocate of title insurance. I always highly recommend to my buyer clients that they entertain and engage. It's the only time they can protect their interest in that property from when they buy the property to anything that may have occurred prior to that property is when they go to settlement. And I tell them of several different scenarios that I have seen where title insurance has saved the day. There's nothing worse than selling your property and going to settlement and find out that either some lien wasn't released or something wasn't copacetic with that title years ago, and then that title company that did that transaction is out of business and nobody knows where those records are. So in order to get the issue resolved, it takes longer than a couple minutes to get this resolved. Now, without title insurance, guess what? The buyer is not going to proceed. If your seller has title insurance and the title insurance is going to cover this blemish and take care of it, most of the time the buyer is going to proceed without any problem. I have seen it several times. And I always recommend to my buyers that they entertain and seriously think about title insurance. It's normally the biggest purchase of most people's lives. There's nothing worse than finding out you're dangling out there, and we all see it, right? I mean, we all see it. I mean, think of a property sometimes that's owned by numerous people, right? We don't know how those transactions occurred 20 years ago. Did everybody sign correctly? Was there an estate sale? Did all the heirs say they were okay with the sale of the property and not contest it? Is somebody going to wake up 20 years later and say, what happened to old Grandma Mary's house up in Lorton, Virginia, and realize that they didn't get their proceeds from that house because they never even knew Grandma died, right? So now they go and they contest it, and 2 transactions later, your buyer has bought the property without title insurance. It could be a very sticky situation for them. Paragraph 20 is notice of possible liens of mechanic liens, right? So this paragraph, pretty much you're having a discussion with your buyer that the seller is getting the property ready for sale. Of course, any work that was done to the property, a vendor has a right to file, if the debt goes unpaid, they have a right to file within 90 days from when the work, I believe 90 days from when the work was done or the improvement was done. So say they finished the work up the day before that they put the property on the market, you ratified shortly after that, and you're going to settlement in 30 days or less. Guess what? That's well within the 90-day time period that someone could file a mechanics lien on the property, and that's going to be filed directly on the property, whether it's owned by you or it's owned by you. They don't care who owns it. They're going to file that mechanics lien on the property for whatever that debt is. And how are we going to know that ahead of time as buyer's agents? We're not, right? So what's one way we can protect our buyers to make sure that they are covered for any type of mechanics liens that are filed on the property? Title insurance enhanced policy covers mechanics liens, right? So another piece of information when you're talking about this with your client, when you're going to ratify the contract, is to let them know about title insurance, right? And the enhanced policy to go along with that. So, that covers the mechanics lien section, paragraph 20, and there was a question back there in the back of the room.
Do you know if Cardinal will pull a preliminary title for us to answer that question?
Remember now, pulling title is only a snapshot in time. So if they pull title on a property, there is a fee, of course, associated with that. I know a lot of title companies, if you're doing regular business with them, could do a soft pull of title to let you know. Of course, there is a fee for that. They may absorb it, but if every time you're going to write an offer on a property, you're going to ask them to pull title on, they may not be overly excited about doing that. But if you're buying a property that's had a lot of work done to it and you've ratified a contract, and you say you have, a home inspection within 7 days or whatever, and you have a contingency for a short period of time, it may be something that you may want to ask the title company to do right away. Hey, there's a potential here that we're worried about potential mechanics liens. Can you run title on this and see if there's any unresolved liens on this property? And they can do that right away and tell you, because they normally pull title fairly quickly. Sometimes it sits in a folder for a little while, but you could always have them do it right away to find out if there's any issues. But once again, the vendor has 90 days from the date that they complete the work to remove their equipment from the property. So just because there isn't any doesn't mean that there isn't any, right? Was that a yogiism, right? Just because there isn't any, there isn't any. Right? So, but thank you for the question. Paragraph 21 is fees. This just kind of outlines to our buyer and seller what fees they may incur in this transaction. Congestion relief, grantor's tax, those type of things, any county local taxes, who's responsible for those fees, and what are outlined in paragraph 21. You can always, sometimes your buyer is always asking, how much is it going to cost? How is this all going to affect me? I always go to their lender and I say, hey, can we put a some sort of a estimated cost, what are they, I'm drawing a blank, somebody help me out here. But the estimated, so that way your buyer can see what their costs are, right? Sellers sometimes ask for those things too, right? So you should know what your rates are in whatever jurisdiction that you're, because most of the time I always tell the seller it's going to be compensation, whatever you're paying in compensation, settlement fee. You always have to pay for the preparation of the deed, plus the county and the state are going to take money from you. They love you, give me your money. And normally that is in the form of the congestion relief tax. I think we've been paying that tax for, what, 10 years now? Has anybody noticed a reduction in congestion? No, me neither. What are they doing with that money? I'd like to know. So know your ratios in regards to how much that's going to cost, right? So I always say, okay, it's a $600,000 house. I think between the congestion relief and the grantor's tax, I just normally multiply by 3, $1,800. $1,800 plus whatever you're paying to whatever title company, about $1,000, roughly $1,200 plus commissions. Gives you a rough idea of how much your fees will be at settlement, right? Paragraph 22 is your broker compensation. This is the most important paragraph in the contract, right? No. Okay, so parties irrevocably instruct the settlement agent to pay the broker compensation at settlement as set forth in the parties' prospective brokerage representation agreements. So you may get a settlement company calling and ask you for a copy of your brokerage agreement. Why? Because they're supposed to pay you as per your brokerage agreement. So if on page 1 you have either no compensation outlined in there or 1%, and maybe you've told the title company that you're expecting to get paid 2%, so maybe 1% is coming from your buyer, they're going to want to see a copy of your brokerage agreement. So you may be asked to provide that so that they can see that there's a signed document that says that that buyer is obligated to pay you a certain amount of commission. So be ready for that. 23, adjustments. This is just letting the buyer and the seller know that there are going to be adjustments on the ALTA for things that maybe the seller paid already and the buyer has to compensate them for, or vice versa, i.e. the taxes, right? So tax bills are normally due in June and December. So say we're settling in October, which is right now. The seller that's currently living in the property hasn't paid their taxes since sometime at the end of June. So they're going to have to pay the buyer, because the buyer is the one that's going to incur that tax bill in December. So they're going to have to pay the buyer for those days that they lived in the property from July 1st to when they settle on the property. So there's going to be all kinds of adjustments on there for all these type of things. Just make sure your buyer is aware of them so they're not surprised. So this is just outlining what those adjustments may be. Paragraph 24 is attorney's fees. The thing with this paragraph really is just make sure that your buyer understands or your client understands two things. One is we're not attorneys, we're real estate professionals, right? If we ever get to a point in the process where I recommend that you go to an attorney, this attorney's fees paragraph may come into effect if we get to that position. Now, the second part to remember when we're talking to our client is if we're in the right, your attorney's fees most likely will get reimbursed to you. If you're in the wrong, then you may have to pay for your own attorney's fees and whatever it is that they're coming after you for. So our contract provides a provision for reimbursement of attorney's fees, which is a nice thing for our clients, right? But just make sure that they're aware of that. We're not attorneys, right? Unless you are an attorney, then that's different. So we do have real estate agents here that are attorneys as well. So they could say they're an attorney, but I can't. And then there's a question up front here.
Is that considered small claims court or circuit court?
It depends on the cost, right? I mean, if we're talking about two parties that can't agree to go to settlement, it's probably going to end up in circuit court. If we're talking about two parties, who can't agree on the repair of HOA items, the buyer could end up going after them in small claims court at the end of the transaction, right? So it all depends. Paragraph 25, everyone's favorite paragraph, is the default paragraph. Now, this is always a great paragraph to read, to have your clients read, right? I've seen some agents that actually make their clients initial this paragraph so that they understand the ramifications of default, right? And there's a rumor out there that I can walk away from a contract and all I'm responsible for is the earnest money deposit. The worst I could do is just lose my EMD. And that is the furthest from the truth. That could be the best that you could possibly do sometimes. So there's a couple paragraphs in here that are kind of worth talking about. If the buyer fails to complete settlement for any reason other than default by the seller, the buyer will be in default, and at the option of the seller, deposit may be forfeited to the seller as liquidated damages and not as a penalty. In such event, buyer will be relieved from further liability. So that's what we would like, right? If we get into a situation where our buyer is in default, we would like to figure out a way where our buyer could get out and walk away without any future liability to this transaction. If the seller does not elect to accept the deposit as liquidated damages, deposit may not be the limit of the buyer's liability in the event of a default. Buyer and the seller knowingly, freely, and voluntarily waive any defense as to the validity of liquidated damages under the contract, including seller's option to elect liquidated damages or pursue actual damages, or that such liquidated damages are void as penalties or are not reasonably related to the actual damages. So we're working with a buyer, right? It's April. We ratify a contract. The market's hot. Thank God the market's hot, right? But we got in. There was 57 offers. We ratified, right? And 30 days later, it's a week before settlement, and our buyer says, hey, we've decided we don't want to buy this property any longer. We want to move on. Well, that could be great for your buyer. Why? Because the market's hot. Prices may have increased. You may be able to get out of the deal for half of your deposit, all of your deposit, whatever. Because the seller knows they can turn around and they can put that property back on the market tomorrow and maybe get more than what they sold it to you for, right? That's April, May. Now it's October, okay? Same scenario. You get under contract. The property's been on the market already for 30 days. You ratify, and somewhere along the line later on, your buyer decides they don't want to buy the property, and they call you and they say, hey, Steve, we don't want to buy this property any longer. We're not going to go to settlement in 2 weeks. Get us out. The seller may not take the earnest money deposit as damages. They may say to themselves, hey, it took us 30 days to get this contract. The market is slow. If we put the property back on the market, it may take us another 30 to 60 days to get it under contract. We may end up taking an offer for less money. Well, we're not going to do anything until we know exactly what our losses are before we entertain. So you may keep them under contract, right? So you can't switch. So there's 2 weeks before settlement. We're the listing agent. We can't do anything, right? We have to go to settlement, right, in order to hold this buyer in default. Or we have to accept the X amount of dollars that they have in earnest money and walk away now to put the property back on the market ASAP. The question is, which scenario are you going to do? You have to kind of work it through with your seller. What do you think is the most advantageous? And then from there, you have to put your buyer in default. And then once you put the buyer in default by sending over a notice, then you could put the property back in active status and seek another buyer. Does the buyer at that point, the previous buyer, have any rights or responsibilities or obligations on that property any longer? No, right? They're in default. They have lost their right to buy the property. Now, people say all the time, I've seen properties that have gone past settlement and they go to settlement a week later. Well, the buyer and the seller can mutually agree somewhere along the way to resurrect that contract and go to settlement, and everybody's happy, everybody's happy about it. But theoretically, on the day of settlement, that contract has died. And the seller now is free to do whatever they would like to do, put that property back to active status, seek another buyer, take it off the market, whatever. I would be a little leery about taking it off the market if your seller is actually going to try and seek actual damages, because how do you establish actual damages if the property doesn't go back on the market until May or April, and today's November? So you have to work through the process. So any questions? I knew I explained that very thoroughly, so I wasn't expecting any. You guys are awesome. No, really, no questions? Excellent. So then the other part of this paragraph that always kind of gets lost in it is, I have a buyer and they have decided to void the contract on the home inspection. We send over the notice voiding the contract along with a copy of the home inspection report, and the seller refuses to, and a release of contract and deposit, and the seller refuses to sign the release. Okay? My buyer has effectively voided that contract. Why? Because they had a contractual right to do so. However, the seller, for some reason, is pissed off for whatever reason because they chose us out of 17 contracts, and they're mad, and they don't want to sign the release, and they're holding your client's $20,000 at bay for whatever reason. This last paragraph, in this paragraph, I always say, give them a little bit of time. They're mad, right? They're pissed off. Give them a little bit of a time. Then send the listing agent a little note that says, hey, you may want to revisit the last paragraph in paragraph 25 and relay that on to your seller, because my clients are getting ready to seek legal advice in regards to getting their money back. So when it says, if either the seller or the buyer refuses to execute a release of deposit when requested to do so in writing, and a court finds that such party should have executed the release, the party who so refused to execute the release will pay the expenses, including without limitations, reasonable attorney's fees incurred by the other party in the litigation. So not only did the seller want to hold your money at bay, they could also be liable for your attorney's costs and court costs and all those extra costs. Do you think that seller wants more money flowing out of their pockets? 9 out of 10 times they're going to sign that release as quickly as possible after you send that notification to them. So the seller doesn't sign your release within 24 hours, don't worry, right? You don't have to get all worried about it. You don't have to call Mike Briggs or Dave Werfel or Steve Lefave or any of those guys and say, oh my God, the seller won't sign my release. What am I going to do? We need our money to go buy another property. Okay? Give them a little time. Let them take some deep breaths and figure it all out. Give them 3 or 4 days, right? I mean, I know we live in a fast-paced society, but not everybody operates on the same fast pace that we do, right? Give them a couple days. Then, a nice little email to the listing agent, say, hey, we've been waiting 5 days for the release, haven't seen it back yet. Just wanted to bring your attention to this paragraph. I'm letting you know this because my client has talked about seeking legal assistance to get their money back. I don't think we want to go down this direction, but just letting you know, if there's any way you can facilitate this, that would be great. Normally within 24 hours of that email, you're going to get your signed release back. And then you could call me up and say, Steve, it worked. You were right. Paragraph 26 is void contract. If a contract becomes void and of no further force and effect without default by either party, both parties will immediately execute a release directing that deposit, if any, be refunded in full to the buyer in accordance with the deposit paragraph. And then paragraph 27 is definitions. So there's a whole slew of definitions here. They've moved things that used to be in other parts of the contract into this definition section. I highlighted a couple on my sheet that I just wanted to make sure that we brought out now. They added business days to this from years past. There didn't used to be a differentiation in business days, but now there is. So whenever it reads in the contract that it's denoted to business days, it means any day that is not a Saturday, Sunday, legal holiday, or a day in which the state or federal government is closed. So now, I'm thinking the earnest money deposit is now business days. So if they have 3 business days to make that deposit and they ratified on this past Friday. Well, Monday was you had Saturday, Sunday, and then Monday was a holiday. So day one, business day, would be today, right? Paragraph 9 is days, or days meaning calendar days. So whenever it just refers to days in your contract anywhere, it's talking calendar days. Unless it denotes business days, it's calendar days. Paragraph number F, for the purpose of computing time period, the first day will be the day following delivery, and the time period will end 9 p.m. on the day specified. So a lot of times people are like, when does this contingency expire for whatever reason, or when does it start? So it starts right on the day following the day of delivery. So I received it today, so day one would be tomorrow, right? Same with the HOA docs, right? HOA docs, even though they don't expire at 9 p.m., the HOA docs seem to be one of the questions I get a lot, is we received the HOA docs on Friday. Is that day one? No. Saturday is day one, right? So Saturday, Sunday, Monday, and then HOA docs expire at 11:59 p.m., right? So, and then number K is a seller subsidy. So this one tells you, is a payment from the seller towards the buyer's charges, including but not limited to loan origination fees, discount points, buy down or subsidy fees, prepaids, or other charges, as allowed by the lender, if any. Seller subsidy reduces total proceeds to the seller at settlement. If a buyer's responsibility to confirm that any lender that the entire credit provided herein may be utilized. If lender prohibits seller from the payment of any portion of this credit, then said credit will be reduced to the amount allowed by the lender. So if you ask for more credits than your buyer can use, then the seller gets that money back. So you can try and reduce the sale price somewhere along the line because you found out halfway through that your buyer can't use all their credits. But how negotiable do you think the seller is going to be at reducing the sale price by, say, 1%, $5,000, $10,000, whatever that might be, to accommodate you when they know that that money is going to come to them anyways, right? So maybe they may be accommodating, but they may not be. So make sure that you do your homework up front so that your buyer can utilize all the credits that you're asking for. Paragraph 28 is the time is of the essence paragraph. Now, if you're having a dispute over earnest money deposit, they may not read that paragraph, but it's just telling that moving this stuff back and forth as quickly as possible is the best for all parties. So time is of the essence, right? This is recent, so it's in my brain, right? Just the other day, agent calls and says, Steve, we received an offer for a property, and we've been on the market for 20 days. We received an offer. It was low. We've been negotiating back and forth. We have a counter offer back to the buyer, and they've had it for 4 hours now, and we just received another offer at full price. What do we do? So I said, well, you have to withdraw your counter offer that you have with buyer number one, and then accept what you got from buyer number two. So when you're the buyer agent, right? The moral of the story is you're the buyer agent, right? And you're trying to ratify a contract. Get that buyer to initial and sign off little things as quickly as possible, because guess what? They just lost a house, right? Because it was 4 or 5 or 6 hours between the time that the agent sent over the documents for initials by the buyer, and in that time frame they got another offer, full price, and they decided to take offer number 2. So don't be that agent or make sure your buyers understand that time is of the essence. right? Get this stuff as quickly as possible. Let's secure this property. Let's not rejoice and be glad until we actually have it, right? So initial sign. Sometimes we have clients that work for the federal government, you know, they're indisposed of for whatever reason. Try and make sure that they understand that they have something that needs to be initialed or signed ASAP. Whether you have to call them directly at their phone, know their office phone, right? I mean, a lot of times we have all their cell phone numbers, but we don't have their office. If I have a person that works, you know, that they can't bring their cell phone into work, I ask them for what's your office number? So if I have to reach you, I can, just for this purpose alone. Paragraph 29 is real estate licensed parties. So if your client is a active or inactive licensee or anybody a party to the contract is, make sure you fill out this paragraph. Paragraph 30, entire agreement. So this buyer and seller should carefully read the contract to be sure that the terms accurately express their agreement. All contracts for the sale of real property, including any changes or addendum, must be written to be enforceable. Written to be enforceable, right? Contracts will be binding upon the parties and each of their respective heirs. So if you're in a contract and that buyer or seller potentially passes away during the contract terms, this says that they are responsible for going all the way to settlement, right? Their heirs are responsible for doing that. The provisions not satisfied at settlement will survive the delivery of the deed and will not be merged therein. So if you have unresolved issues, i.e. HOA violations or stuff like that that was not resolved by the seller, this lets you know that they're not abstained from that whole process. So just because they signed at settlement does not resolve those issues if that buyer hasn't agreed to the terms that the seller is providing them. So that's why the buyer is able to take them to court if they need to do that for whatever those issues are. Survivability in the event any provision of this contract is determined to be unenforceable, the remaining terms and provisions of the contract shall not in any way be affected, impaired, or invalidated. And then 32 is assignability. This happens on occasion where you have a client who wants to somewhere along the line either assign it to a company like an LLC or a corporation. This is just saying that without the seller's permission, that can't be done. 33 is additions. Here you're just going to make sure that you're going to check the boxes for any additional items that you're going to incorporate into your contract. So you would check all those boxes. If there's an others box in there, if there's something that isn't specified, you could write that in. So I prepared this contract. It's ratified. Make sure this date of ratification gets filled in. And then on the last page is the seller buyers signing page, and then the information for the listing broker and the buyer broker, okay? So on page 1 of here, right, if you're selling this unrepresented as a listing agent and you're filling out this contract for your buyer, then the buyer broker side should be blank or NA, right? Please don't put my information in your contract as a listing agent, okay? You think it's funny, but I get arbitrary emails from lenders and settlement companies for contracts that people put me in as a buyer's agent, and I'm not, okay? So it's always SkySlope's fault, of course, but data, what do they say? Data in, data out, right? So look, which tells me, right, in the day of electronics, right, we fill this stuff out and we don't look it over, right? So look your documents over visually before you send them in to your clients for signature, or before you send them over to this other side to look at for looking at, for ratifying. So don't rely on myself or Mike or whatever to be the teacher, to look over your stuff to make sure that everything was done correctly, right? We try and do our best, right? But think about it, we have a lot of agents here at Sampson, right? It's hard to look over everything. But I can tell you, and this year alone, I have probably gotten 10 or 12 different emails from either title companies or lenders asking me for information about a buyer I've never heard of. And it's kind of embarrassing for our agents, right? I mean, I shouldn't say anything because I'm going to have multi-million dollars of sales at the end of the year, right? Because all these people have graciously put my name in as a buyer agent. But it is, make sure you fill out your stuff and look it over correctly. And I would highly recommend, if you're working with a buyer for the first time, sit down with them and go through this document like we have gone over the last 2 days, or two periods looking through this document, because first-time home buyers don't know what they don't know, right? So you have to educate them and tell them what they know and what they don't know. So don't throw these to them electronically, because most people are signing these documents right here on this thing, right? Do you think they can read this document on this thing? No, right? I mean, I don't even like to sign these that come, or the brokerage agreements. I don't even like to sign them on here because I can't really look them over. I'm constantly magnifying and bringing it down to scroll up, down, up. After a while, I'm like, just sign it, right? So that that's my say in it. So make sure your first-time home buyers, you sit down and go over it, and make sure you look. I know we're doing this electronically now. Make sure you look it over. After you generate it, look it over the best you can before you send it on, because it makes you look better as a buyer agent when you're sending a contract over that is complete and looks good, and makes it easy for the listing agent to recommend to their client to sign off on. So, all right, thank you.